Okay, thank you. If you're joining us now, welcome to the part two of day three of our 2026 Legal Aid Fair. We have had so far some interesting topics, and we invite you to scroll the YouTube channel for additional presentations. I am Janett Levy, and I'm attorney at law and tutor of the Legal Aid Clinic. I'm going to invite Miss Georgina White to come and introduce Group D, the presenters and actors for this morning's session.
Good day. Our presentation today is entitled, What is Your Will? We will be guiding you on how to create a will, on what is a will, the effects of a will, what makes a will valid, and we will be presenting a sample will, and also a few common mistakes made when making a will. Before we carry on with our presentation, our group members in Group D will be doing a skit first. I will hand over.
Good morning, guys. So, our group will be presenting a skit, signing with certainty on how to properly execute a will. We'll begin. Mr. Samuels, good morning.
Good morning.
Nice to see you again. Debbie.
Good morning.
Carl.
Nice to meet you.
Thank you for taking the time out today for Mr. Samuels to act as witnesses. Before we begin, I have a few vital questions for you, Mr. Samuels, just to ensure that everything is in complying with the Wills Act of Jamaica.
Sure.
First, for the record, Mr. Samuels, are you sure you're over the age of 18? You sure look quite young.
Yes, I am. I'm actually much more older than that. Yes, I am I've passed that age a long time ago. I wish I looked as young as you.
Excellent. As no one under the age of 18 can make a will, it would be considered invalid. More importantly, are you here today of your own free will? And is your mind completely unaffected by any duress, fraud, or coercion from others?
Absolutely. This is my own decision, and I just want to have my property distributed. So when I go, my children can live on and carry my legacy.
I'm glad to hear that. As the law requires your mind to be rational and capable of transacting your ordinary affairs. I also want to note how important it is that you are doing this today, Mr. Samuels. Generally speaking, because you are currently unmarried, if you were to pass away without a will, what we call intestacy, the distribution of your estate could be extremely contentious. In other words, people love fight over dead left.
So hold on, tell me, why would it be more contentious just because he's not married?
Well, Carl, without a will, the law dictates that specific order of relatives will inherit. This is under the Interstate Estates and Property Charges Act. If there is no spouse, the estate is divided among children, parents, or other relatives in very specific order. Where a common law partner exists, they would have to apply for a declaration of spouseship to be recognized as a spouse in order to inherit. And if there are children born out of wedlock, these names whose names aren't on a birth certificate, they would need declaration of paternity to inherit. So a will avoids all those potential legal battles by making your intentions clear.
So, what would happen if Mr. Samuels were to get married?
That's a crucial question, Debbie. Well, under Section 13 of the Wills Act, a will is automatically revoked by the subsequent marriage of the testator. So if Mr. Samuels got married tomorrow, this will we're signing today would be void by operation of the law, and he would have to execute a new one.
Ah, that makes sense. So, what happens now?
Well, next is the most crucial part. The signature must be made or acknowledged by Mr. Samuels in the joint presence of both of you present at the same time. Carl, if you are to step out, we'd have to do all this over again. We'd have to do it over.
Oh, sorry. It's a good thing you stopped me. I was about to step out. My bad.
You both must actually see him sign or him acknowledge the signature he has already made.
So, is our only job as witnesses to watch Mr. Samuel sign? Is that the only reason we're here today? Just to watch him put pen on paper?
Of course not. After Mr. Samuel signs in your presence, then both of you guys must attest and subscribe the will. In Mr. Samuel's presence. However, you guys don't need to see the contents of Mr. Samuel's will. Only your signatures are required.
So where exactly would Mr. Samuels need to sign on this document?
Okay, so Section 6 states that the will must be in writing, as we have prepared today, and signed at the foot or end of the document. The law is flexible. The signature can be beside or opposite the end, as long as it is apparent he intended to give effect to the will. However, anything written underneath or following his signature will have no legal effect.
All right, I'm signing now. Carl and Debbie, keep your eyes on my pen, please.
Perfect. Carl, you sign here as the first witness.
All right. There we go.
And finally, Debbie, you sign right there.
Finally, my turn now.
Thank you. Now, just to be safe, I've included an attestation clause at the end. While not strictly mandatory, to make the will valid, it raises a presumption that all these formalities were actually followed if everyone ever challenges it in court.
Oh, wait, I remember something. Is it true that witnesses cannot benefit from a will, meaning say we couldn't get nothing because we signed?
Good point, Debbie. Under Section 10 of the Wills Act, if a person witnesses a will, any gift or beneficial device made to them or even to their husband or wife is utterly null and void. The will stays valid, however, but the witnesses lose their inheritance. There's a 2015 amendment in Jamaica that allows a witness to apply to the Supreme Court to try and save the gift if there was no fraud. It is a complex process, and we would want to avoid that.
Don't worry, guys. I'm paying you in lunch. So, you guys aren't in the will, so I'll see you guys at Uncorked later, okay?
Okay.
Perfect. Then we're all set. We have the written document signed at the end by you, Mr. Samuels, a capable testator in the joint presence of both of your witnesses, Carl and Debbie, who have now signed, and the will is officially executed. Thank you.
Thank you, fellow group mates, for that informative skit, which definitely highlighted key features of a will and how to properly duly execute a will in accordance with the Wills Act. Our presenters today are myself, Georgina White, Shamara Crossfield, Namarja Jarrett, and Dana Johnson. So these are the topics that will be discussed today. And we will start with, what is a will? So what is a will? A will is a written declaration complying with statutory requirements of a person's intention concerning matters which he or she desires to take effect after death. The person making the will is described as the testator or testatrix, depending on the gender. And per the case of Douglas Menzies and Umflably, a person can only make one will. You can only have one will. So, a will can be contained in more than one instrument. It can be contained in a primary document called a will and a subsidiary document called a codicil, which can be used to modify or edit a will. We'll move on to the next topic. Shamar?
Okay, so as we can see here, we are of the understanding that a will is testamentary in nature. A will operates only upon death. It has no legal effect during the testator's lifetime. Until death, it remains ambulatory, meaning changeable. And the testator may revoke it during their lifetime. A will contains a person's instructions regarding the distribution of property. A will can dispose of property owned at the time it is made, property acquired after it is made, and property owned at the time of the death. Now, a will does not transfer property immediately. It becomes legally operative only upon death. Before death, the testator retains full ownership and control. Now, at this time, Narmarja will be discussing what is the purpose of a will. Everybody give him a round of applause as he makes his way.
Okay, so one of the purposes of a will is the control over distribution of assets. So a will allows a person to decide who receives their property. A will gives the testator full testamentary freedom to determine who benefits from their estate. This may include family members, friends, charities, or other entities. Without a will, the law decides who inherits, which may not reflect the deceased's personal wishes. Assets are distributed according to personal wishes, as the testator can make specific gifts, example, land, money, or other personal items, or divide the estate in fixed shares. Conditions may also be attached to gifts provided they are legally valid. This ensures that sentimental, financial, or strategic decisions about property are respected after death. Additionally, it prevents the estate from falling under intestacy rules. As previously mentioned, if a person dies without a valid will, their estate is distributed according to statutory intestacy provisions. These rules follow a fixed order of relatives and may exclude close companions, stepchildren, or friends. Therefore, a valid will avoids this rigid framework and ensures intentional distribution. It allows for the appointment of an executor. So the will allows for the testator to appoint an executor. The executor is the person chosen to carry out the instructions in the will. This appointment reflects the testator's trust and confidence in that individual. The testator may appoint more than one executor or name a substitute if the first is unable to act. The executor administers the estate. Administration includes identifying assets, paying debts and taxes, and distributing the remaining estate to beneficiaries. The executor acts as a personal representative and owes fiduciary duties to the estate and beneficiaries. Proper administration ensures legal compliance and orderly settlement. Additionally, this person has legal control over the assets until distribution. Upon death, the executor derives authority from the will, and they hold the estate on trust for the beneficiaries. During this period, beneficiaries do not have direct control over the assets. Immediate authority after death. The executor can begin administering the estate. Although probate formalizes authority, an executor's powers stem from the will itself. Early steps may include securing property and preserving assets. This helps prevent loss, waste, or mismanagement. Funeral arrangements may be guided by the will. A testator may include instructions regarding burial, cremation, or other funeral preferences. While such wishes are not strictly binding in all circumstances, they are generally respected by the executor. This provides guidance and reduces uncertainty during a difficult time. It ensures orderly management of assets. Clear instructions reduce confusion about ownership and distribution. The executor's structured role ensures debts are settled before beneficiaries receive their shares, and this promotes lawful and efficient estate administration. Protection and certainty. So the will provides clarity for beneficiaries. A properly drafted will clearly identifies beneficiaries and the extent of their entitlement. This reduces ambiguity and potential misinterpretation. Clear drafting minimizes the risk of litigation. It reduces family disputes as well. Express written instructions limit disagreements about what the deceased would have wanted. While disputes can still arise, a valid will significantly lowers the likelihood of conflict. It provides an objective reference point for distribution. Additionally, the will ensures loved ones are provided for. A will allows financial provisions for dependents, minor children, or vulnerable beneficiaries. Trusts may also be created for long-term protection. This ensures continued care and support in accordance with the testator's intention. And that is the end of my segment, and we will move on to what makes a will valid.
Yes, so hello again, everyone. We'll be looking at what makes a will valid. Now, in considering to make a will, it is important to have an understanding of what makes such a will valid, what you should or should not do, and what procedural steps are required when it comes on to the actual execution of a will, as was demonstrated earlier in our skit. Now, the first point to note is that the will must be made in writing. This is as stated in Section 6 of the Wills Act. An oral understanding or communication is not sufficient. Wills in and of themselves are not to be implied. They are to be written, and the apportionment of devices and legacies are to be explicitly stated in the will. Secondly, the maker of the will must have the requisite mental capacity to do so. So it says the maker must have the necessary mental capacity. This includes attaining the age of majority and his mind being unaffected by anything such as duress, fraud, or insanity. So that therefore means that a child, for example, cannot create a will. A person under the age of 18 cannot create a will, and Section 5 of the Wills Act makes this explicitly clear. Additionally, persons who are mentally unwell do not have the mental capacity to create a will. Now, once we've established that we're going to write out our will and we have the required mental capacity, after devising and bequeathing, we need to now ensure that the will is properly executed. So consider that in order for the will to be valid, it must be signed by the testator or by a third party at the direction and in the presence of the testator, in the joint presence of at least 2 witnesses. This process requires both witnesses to be physically and mentally present. That means they should not look away. They should see that the testator or testatrix has signed. In a case where someone else signed on behalf of the testator must acknowledge the signature in the joint presence of the witnesses. And the reference is made to the case of Keegwin and Keegwin, which has shown that a will is validly executed even if the testator presents it with an existing signature to 2 witnesses who then attest it in their presence. The witness must not be distracted. They must witness the signing or acknowledgement. The case of Brown and Scurrow is authority to say that if one witness does not see the signing or is not aware of it, then the will cannot be considered properly executed and is invalid. And fourthly, by the Wills Act, the witnesses must attest the testator or testatrix signature in his or her presence. The witness need not see the contents of the will, only the signature. Now, there are a number of different nuances that exist. However, once these key steps in execution are properly completed, you can bet your bottom dollar that the will is more likely than not going to be considered valid. Now, at this time, we're going to move on to the effect of failure to create a will, and this will be done by Dana Johnson. Round of applause.
Thank you, Shamar. Okay, so I'm going to be doing, as he said, the effect of failure to create a will. What is it? Okay. Okay, so the first effect is that you will be dying intestate. So you'll be dying without a will. So you'll be unable to direct your instructions to someone that you prefer and how to administer your estate. So this means it will be subject to the laws of intestacy, and who may receive the gifts that you could have potentially put in your will may not be the persons you would have wanted it to do. So it is best and wise to create
a will. So the second effect of not creating a will is that you lose your personal choice. So you can't choose your beneficiaries, you can't choose your executor, and the court will appoint someone else in their stead to administer your estate, which is maybe someone you may or may not agree with. Now, if you die intestate, the court now has to issue letters of administration to someone else, as previously said, and this would be to the administrator. And they would have the statutory power over your estate, and they will have the ability to do whatever it is they want with your estate. So think clearly and carefully on that. The possible practical considerations if you die intestate. Your certain family members that may inherit, that could have inherited, will not. Your partners that you may have been with but were unmarried to, they would not be in the, as was stated before by my previous group member, fall within the rigid line of who can get in the intestacy and in the Intestacy Act, who can receive gifts from your estate, because they would not be in line. They would not be married to you, they would not be your child, so they have no direct familial connection with you. Now, the estate as well may be divided into fixed statutory proportions. So, for example, suppose you have a daughter, but you and your daughter not living good. She can probably all get more than what he want to give her after she just rooted your whole life. Not true? So please decide carefully, because the proportions is not going to be fixed by you. It's going to be fixed by the statute. Okay? So think carefully, guys, because where there's a will, there's a what? There's a way. Yes. Now, I'm going to move on to how a sample of a last will look. And doing that will be another group member of mine. I will be doing it. And I'm going to ask the two persons to come up with the papers so that we can have the physical copies up here. Miss Rochelle and Natasha. Okay, so can this be zoomed? No? Okay. So an example of how your last will and your will can look is you will have this is the last will and testament, and then you would have you of me and your name. So Joy and Brown, your occupation, then your address, and the parish it is located in. I hereby revoke all wills and testamentary depositions and codicils previously made by me, and declare that this is to be my last will and testament. In this section, the next section, you can appoint your executors. So I hereby appoint Dane Smith, teacher of 98 Old Harbor Road, Spanish Town, in the parish of St. Catherine, and Kemar Smith, doctor of 98 Old Harbor Road, Spanish Town, in the parish of St. Catherine, to be the executors of this, my will. I hereby appoint Jane Samuels, social worker of 35 Mona Road, Kingston 6, in the parish of St. Andrew, and Daniel Samuels of also 82 Mona Road, Kingston 6, in the parish of St. Andrew, to be my trustees of this, my will. Now, you can realize that you have two different persons for your executors and your trustees. you can do this, or your executors can be your trustees without you having to state that if you have not appointed anyone else. But it would have to be according to the Statutory Act. I declare that the expression of my trustees herein contained shall include the trustee or trustees hereof, whether original, additional, or substituted, and that my trustees shall be trustees of all the purposes of the Settled Land Act, the Conveyancing Act, and the Intestate and Property Charges Act, and all settlements and trusts deemed to arise thereunder. Now, what will happen further down in the rest of the will is that you will be talking about the gifts that you're going to give to the different persons, whoever you wanted to give. It does not have to be your family members, but it can be your friends, it can be even persons you just met and you just want to, give them something if you die. So it's not strict and not rigid, unlike what would happen if you die intestate. Now, my fellow group members are going to distribute to the lovely people who are here the samples of a will so that you yourself can see what it looks like and ensure you don't die without one. Because again, where there is a will, there is a way. Thank you.
Thank you, Dana. We'll now move on to some of the common mistakes made when making a will. We're getting there eventually. Yes, we're there now. Okay. So some of the common mistakes are that names, your name, as in the testator's name, is sometimes incorrect to what is on their ID, or so they might be missing a middle name. So like your name, John Astor Brown, but on your will you only write John Brown. You need your full name on the will. Also, for persons receiving gifts, you have to put their full names. If their full names or their alias is used, you're going to have to do a separate document. Well, they're going to have to do a separate document after you die when they're trying to probate the will. So the court can be assured to know that the person named in the will is actually the person who is going to get what you had intended to give them. The next mistake commonly made is unattested alterations. So these mean like changes made. So like if you do a little crossing out, or you think, oh, you cross out and that's it. It's done, it's gone, it's out of my will. No. Changes made are invalid unless they are signed and witnessed, like a new will, or if it's made unapparent. And when we mean unapparent, it means it must be completely obliterated, completely mark it out. And if you look at it, you must be able to not see what was there previously if you're making that change. So beneficiaries of a will cannot witness the will. So if you have them witnessing the will, and as my learned colleagues had said before, you can't benefit from that specific gift, but the Jamaica statute allows for that person, that beneficiary, to apply to the court to try to, be able to benefit from it, which I would say good luck. So the next one is failure to include a residuary clause. So we had included some of the benefits of a residuary clause, and basically, any gift that fails or assets that were overlooked would pass via intestacies if there is none. And it complicates the estate's administration. So let's say you have your stuff. Everything that you have is in your estate while you're alive before you die. So it all makes up your estate. Let's say you only will things that you can remember, but you have a few other things that you didn't add in your will, those things fall to intestacy. But if you don't have a residuary clause. But if you have a residuary clause, it will just fall to the people within that clause. So you have a house and you only will the house, but you have a car and you have a couple pots and you have a couple pans. If you have a residuary, you can give those to the people in the residuary. Also, so the next issue is uncertainty of subject or object. Wills often fail when it is unclear. Gifts often fail when it is unclear what is given or to whom. So let's say you have a house and you say in your will, I'm giving my house to John Brown. But you have two houses and you don't describe which house. That's not good. You have to be descriptive and you have to say exactly, specifically which house. And you can probably also specifically describe the John Brown. Let's say you have two cousins named John Brown. Put John Brown, my father, John Brown, the first cousin by whomever. So be very descriptive of who you're giving the gifts to and also the gift. Because you don't want anything that you don't intend to give or who you don't intend to give to somebody different. You want to make it specific so your intentions are accurately, went through with. So physical interference to the will. So damaging the will can require a special affidavit to explain the document's state to the registrar. So as a testator, this is not going to be something that you're considering, but your executor or the beneficiaries are going to have to consider these things after. If you're doing this will to make the people that come after you or that live after you be able to benefit from your estate, try to do it in the most comfortable and effective way. So we talked about obliterations and striking out and that it must be made apparent. And then we're going to move on to the last common mistake made in practice. So witnesses may not have the opportunity to see the testator's signature and the signature isn't complete and apparent. When you are signing, my colleagues had previously and thoroughly explained that both witnesses are to be present at the same time and should be able to see your signature on the will. They don't have to see the entirety of the will itself. They don't have to read the entirety of the will, but they must witness your signature. The whole point of an attesting witness is to be able to see the signature. So you can't get a blind person to attest your will. They must be able to see and know that this is the testator's signature. And that is why they affix their signatures. I hope you all had a wonderful time listening to our presentation. As it now comes to an end, and now I will have Miss Rochelle Graham Barnes doing our closing.
Thank you, Georgina. Good morning, everyone. Ladies and gentlemen, allow me to paraphrase something I once heard. It is not how you start that counts, but it is the continuing to the end that is the true virtue. And with that said, I stand here on behalf of the members of Seminar Group D, Shauna K. Belanfante, Leighton Barrett, Shamar Crossfield, Maya Curtis, Stephen Day, Saskia Foster, Dahima Gibbs, me, Rochelle Graham Barnes, Natasha Holmes, Tyrell James, Narmarja Jarrett, Dana Johnson, Safia Senior, Georgina White, and Shaveen Smith to say thank you for continuing with us to the end of our session today on What's Your Will? First and foremost, thank you to Mrs. Wisdom Barnett and the members of the Norman Manley Law School Legal Aid Clinic who have organized this year's Legal Aid Fair, providing us with an opportunity to share critical information on wills. To our lovely Miss Levy, our seminar tutor. Thank you for your patience, bright, welcoming smiles, guidance, and support to us as we prepared not only for this session, but generally throughout our time here as students honing our craft as soon-to-be attorneys at law. To Mr. Cousins and other members of the Norman Manley Law School who provided Norman Law School team who provided technical and administrative support, thank you. And of course, to our specially invited guests, to those here face to face, thank you for not only being here to support us, but staying throughout the what's in your will. To those who have joined us online from as far as Westmoreland, Trelawney, St. Anne, Clarendon, those outside of the jurisdiction in Canada and the United States, via the Norman Manley Law School's Legal Aid Clinic's YouTube page, thank you, thank you, thank you. We appreciate your support and are humbled that you felt it necessary to join and participate in our session on this very important topic. Ladies and gentlemen, thank you, take care, and I hope you're now more aware of what's in your will.